Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. We have a new letter from Sarah Boone. It's the gift that keeps on giving, known as Sarah Boone. So without any further delay, let me just pull it up because really we all know that's what you're here for. So the letter itself is not very long. I was kind of hoping for a little more content from Sarah, but I don't know if she's just tired, but if she's out there and she still has any of her monkeys or minions or whatever, just let her know that we do appreciate a good letter from Sarah Boone. So again, this is her handwritten. I guess this is the regular school type of lined paper that we get for our kids when we all had in school, and I guess that's pretty much what they get when they are in prison. So she starts it off. At least she's pretty good at her formatting. She's had a lot of practice. In the Circuit Court of the Ninth Judicial Circuit, in and for Orange County, Florida, Brian C. Boone, petitioner. She's got the case number, Division 31, versus Sarah K. Boone, respondent. Respondent's notice of information. Comes now, pro se respondent, Sarah K. Boone, and respectfully submits her notice of information for the Honorable Court's consideration while this family law matter remains open and pending final judgment since the trial held on August 25th, 2025. I guess it's getting to her. Yeah. In the interim, the respondent makes the following statement or statements for awareness of the petitioner, Brian C. Boone, continuing to inappropriately withhold rightful and reasonable parental time between mother and son for no reason other than retaliation and disregard for the court's authority in his harmful, self implemented rules which are not in the best interests of the child. I don't know that I think we would all agree with you on that, Sarah. I think I think your son is probably doing pretty darn well with his dad, and I don't know. I mean, he's at the age now, and we're not going to say his full name, even though we all know it. I'm going to just refer to him as L. I think L can make his own opinion known, and I'm sure he has. One, in the absence of a modified court order since the trial and after both parties' closing arguments were submitted, the respondent has experienced increasing unilateral restrictions imposed by the petitioner, vastly limiting her contact with her minor son. Do you think she uses the library, maybe not the law library? You think she uses the library's dictionary and thesauruses and all that to make sure she can use some of these big girl words? These restrictions of the petitioner include a a I guess that's a permitting only one telephone call per week between the respondent and minor son without a court order authorizing implementation of such restriction. During the Christmas and New Year period, I guess these are B, A, B, and C. Okay, so there you go. B, denying the respondent all holiday parenting time, stating it was his Christmas, she's got that in quotes, according to the parenting plan, and she is, in parentheses again, not family to her through their son while on the telephone prior. Sarah, you can't be a parent while you're in prison for murder. I mean, you know? I mean, he could visit you or call you, but there's no such thing as being a parent behind bars when you're in prison for the rest of your life. C. prevented telephone communication during the child's 2-week winter break by not providing funds for the respondent to call her son. Yeah, I have to side with Brian on that one, hun, because he's tired of giving you money. And I think he's probably spoken with his attorney on this, and I think the freeze in adding funds until the judge tells him he has to, that's probably where things are. And, I have to say, good for you, Brian. Good for you. D. Refused a pre-discussed 15-minute remote video visit on Christmas Day for the 6th consecutive year to allow the minor son to open the respondent's gifts she privately arranged, then pressured the child to open without her in front of the petitioner's family. So, who exactly is getting L these gifts, Sarah? Because I remember previously, before you got found guilty, that you were begging Brian to please buy him this fish soap and all this other garbage. And, I don't know if you have any people that are really helping you. I don't know if your brother's even doing that at this point, but maybe there's a handful, maybe there's one or two at this point. I think you've been burning a lot of bridges. E. Declined a pre-discussed in-person visit with the respondent, which was the last opportunity for the minor son to see her during his entire 2-week holiday break before returning to school. Again, I think Elle probably had some opinions and thoughts on that, and I don't know even if the judge thought that maybe Brian should have maybe tried to do any of these things, do you think that she's going to punish him for that? I don't really think so. What do you guys think? Wherefore, due to the absence of a modified court order generated from the trial, both parties' closings, arguments, and the case as a whole, the respondent's concern is that the petitioner will remain non-compliant in his unreasonable actions and comments, such as the aforementioned, or worse, which are not in the child's best interests and continue to impede the meaningful relationship with her minor son. Best interests of L? I think his best interest is to not have to visit you in prison, Sarah, and not have to get on any phone calls and communications with you unless he's comfortable. But again, if it is ordered until he reaches the age where he's legally allowed to make a decision for himself, there's not much you can do. Of course, you can complain in a letter, which is exactly what you're doing. The respondent respectfully requests this honorable court to graciously consider the post-trial developments in this notice to understand the negative efforts continued by the petitioner and her positive determination in still avidly trying to spend time with her son, however, whenever, and wherever possible, and which are in his best interests at all times. Okay. Respectfully submitted on this 9th day of January 2026, Sarah Boone. I love how she signs it, puts her name, and then she puts pro se respondent, because we all know she just loves to make sure that everybody knows. Because that's one of her favorite things, I think, that she likes to be pro se. And she even added her own certificate of service here. I hereby certify that a true and correct original copy of the foregoing notice of information has been filed with the court via United States Postal Service. She puts in parentheses legal mail. And opposing counsel as follows: on January 9th, 2026, Joshua J. Martell, Esquire, Martell Family Law, and he's in Orlando, Florida. And then, of course, she signs her name again, because we just can't get enough of her name and her signature all over the place. So this was actually a 4-page document, and the last one's just the envelope, and you can see the envelope here where it all came from, and that's pretty much it. I do wonder where she got the stamp from, but I don't know, maybe she's actually working and earning some money there. we can all hope, right, that she's actually doing more than just sitting on her ass. I don't know. I was hoping for I was hoping for something. I don't know. I was hoping for something more, and I hate to say that, but I don't know. I just kind of miss the antics. There is some in here, but I'm hoping that she might write a letter to Judge Kranig soon. Although I feel really bad for him if he gets another one but the last one she wrote when she was requesting to be included in all the her little motion or whatever you want to call it, when she wanted to be included, I loved his response to that. And if you're not familiar with that, you could check out the playlist because everything that comes out on her on both sides, I've been covering it. But what do you guys think? Do you think that Judge Jackson is going to care about this complaint that she's sent in? I'm pretty sure she's probably read it, and I don't want to put, words or emotions or anything in her mouth, but I don't know. Do you think she thought it was humorous? I mean, obviously, it's not funny to have to deal with a family court situation. And again, Brian and Elle deserve to move on and not have to deal with all this crap. I mean, truly, they don't. And I don't know what her decision's going to be, but I hope it truly is, not having Brian have to deal with her any more than he has to. And then same thing with Elle. And then when he hits a little bit older, hopefully he can make some decisions on his own and tell the courts that I don't want anything to do with her if that's what he wants. Because when he gets, as he ages, he's about 15 now. So as he gets older, he's going to be able to truly speak for himself, even though I think he can speak for himself now. But I don't know how much longer it's going to take for Judge Jackson to put her decision out. The current stuff, it does seem to be non-public anymore, but a decision has not posted. And I know some folks have asked, well, could they have a decision and not post it on the docket? No, it will still be posted on the docket. It may not be available to just anyone, but it should be posted on the docket. Anything that comes out through the judge as far as a decision is concerned, and trust me, it will be made public one way or another. Somebody will get a hold of it, and and everyone will know. But let me know you guys' thoughts in the comments as always. And with that said, I hope you have a great rest of the day, and most of all, stay safe.